Bao Tran. I have the honor here of presenting to you about the implications of the America Invents Act. With us is Mark Reyland, and he's the Executive Director for the United Inventors Association, one of the largest associations of inventors there is.
Hi, my name is Mark Reyland. I'm the Executive Director of the United Inventors Association of America. For those of you who don't know what the UIA is, we're the largest inventor organization in the country. We were started about 27 years ago by the U.S. Patent and Trademark Office to help inventors understand the educational and commercialization processes of taking products to market. Obviously, as a national organization for the industry, we're very interested in the effects of AIA on the individual inventors. So we've been very active with the PTO over the last several years as the bill has gone through its passage. Bao Tran and his company Tran & Associates, who is a patent firm out of San Francisco, is a very active member of the UIA, very actively involved in helping the UIA understand these issues, and was a very strategic partner with us in developing a tool that we think is important for the inventors to have access to in responding to the changes of the American Invents Act. So, with that said, we're going to talk about these issues that have to deal with the American Invents Act, and a little bit about the law itself. We're going to talk about how law is made, just so that you have a point of reference, how the law came to be, what rules development is, how the first to invent versus first inventor to file section of the law impacts you. What should I do with my inventor's notebook? It's a big question we get asked a lot. Tips and tricks about what kind of patents to file, and what is the best way to file a PPA in light of this new law. So we're going to talk first about how a basic law is made. Just as a point of reference, laws are introduced as a bill into a referral committee. That committee in either the House or the Senate has hearings, listens to all sides of the issues associated with that proposed piece of legislation, and then produces what's called a committee report. That committee report then goes to the floor of either the House or the Senate for a vote. If it goes to the House first, then it gets voted on. If it passes, it goes on to the Senate. That floor vote is very important because it's basically the yes-no gate for any piece of legislation. Once the vote is done, it's referred to the other chamber where it's voted on. Oftentimes it goes to committee and then vote. And then when both chambers have had a chance to committee and vote on it, then they will do a conference. So the conference is a nonpartisan, bipartisan group of both houses that come together to work out any differences between the versions. Once that's done, it's sent on to the President for signature. To put the American Invents Act in reference, this process I just described in about 30 seconds took over 11 years to do. So laws are big animals. It's a lot of stuff in a law. Oftentimes, when laws are very complicated and they have very complicated implementation, they use a process called rules making. And rules making is when, after the legislation is signed by the President, the governing body or the enacting body for the legislation, in this case the USPTO, is charged with developing a set of rules for how this will be implemented. Rules making is a process that's currently ongoing. It will go on for the full 18-month implementation cycle of the AIA. It's about halfway done. In fact, right now is the rules implementation public comment sector for how to address the first inventor to file section of the law that goes into effect in March. That's open until the 5th of October, I believe, where you as the public can then go and comment on it, and the PTO has to take those comments and fold all that into what will be eventually the rules of how the law is implemented on a day-to-day basis. So the rules for laws like this get very lengthy, where the legislation itself isn't as lengthy as often as the rules. So now that we know how this process works, let's look at some of the major changes created by the law itself. Bao can explain those.
Yes, the major changes to the AIA, we can summarize it up into three major sections. So we have what is called first inventor to file. And this creates a race to the Patent Office for filing purposes. And so the implications of this new rule is to accelerate the patent filing process. Patent applications are going to be segregated according to the March 16, 2000 deadline. So cases prior to March 16 will be accorded the traditional the date when you actually conceive of the invention, whereas cases after March 16, 2013, it will be whoever wins the race to the Patent Office. So one implication of this is we recommend is that prior to March, the inventors should file all their applications, and thereby get the benefit of the old system in advance. So the second implication of this race to the Patent Office for filing is that interferences will be eliminated. So interferences are proceedings in which the inventors show to the Patent Office that they have they were the earlier inventor. They first conceive of the invention, and then they diligently worked on experimentation, and then finally they file the case. As long as they can chain that with diligence, they can get move their invention date from the filing date all the way back up to when they first came up with the concept. Now, of course, with the new system, that's the race to the Patent Office, interferences will no longer be needed. Now, there is a wrinkle that the AIA has added to this, which is called post-grant opposition. So that procedure allows inventors to examine recently issued patents, and then you can challenge those patents if you think that the inventor of the patent actually derived the idea from you. So the implication of this is that you are going to have to monitor newly issued patents in the space that you invent in. So this adds an extra layer of work. However, this will be very useful because I think you should do this independent of the requirement, because you should know what your competition is doing. So in general, I think that's a good thing to do at any rate. So next, we're going to walk through the traditional way of determining the date of inventorship. So in this example, let's say inventor A conceived of the invention first. So and subsequent to inventor A, you have inventor B who invents behind inventor A, but at some point file a patent application ahead of inventor A. So now in our existing system, inventor A conceives first, and then he can spend time exploring commercialization possibilities. For example, he'll search the prior art, he'll do his market analysis, and then she can go to perhaps the potential customers to see if there's any interest in the invention. And then assuming that the answer is positive to the search and the market analysis, the inventor can hire an attorney to draft and file a patent application. And this may take some time, but as long as that is coupled to due diligence, to diligence in doing this, i.e., you continuously work toward the next objective. Whenever you file, that filing date may be a long time from the date of the conception, but as long as you have diligence, you can chain it back. So after you file, the application will go through the normal U.S. Patent Office procedure in examining the case. And the use of the notebook in the old way is you can chain your invention activities and your commercialization and your reduction to practice, and you can chain your filing date all the way back to your conception date. And so as the graphic indicates, the lag between conception and filing can be very long, a few years, but you can still get that time back if you show that you are diligent and if you have enough proof proof of diligence. So in that case, Inventor A wins. So this is the system that exists now up until March of 2013. So now let's switch into March what happens on March 2013. So you will still have the same activity where the Inventor A invents, however, Inventor B in this case invents and file it faster, and because the new system grants the filing date as of the filing date, Inventor B will file regardless of when.
2 years ago, and because we knew as AIA passed, and at that point it was very evident that the law was going to pass, that an inventor could lose their rights because they went to their patent attorney in Florida and said, hey, will you file this provisional? And the patent attorney said, oh, sure, no problem. I'm going on vacation next week. I'll do it right when I get back. And while the patent attorney is on vacation, a guy in Oregon comes up with the same idea. Unbeknownst to the person in Florida, the person in Oregon is going through the same process. The only difference is his patent attorney didn't go on vacation. So we needed to take a look at the impact of pro se filing, which is filing by yourself without the use of a patent attorney, and the increase in pro se that was going to occur naturally because of this law, and look at tools. There are several books out there, there are several tools out there that help inventors, author PPAs. We really wanted to make sure that there was at least one really good tool out there that did it well and gave you the ability as an inventor to file this PPA in a very timely manner, and was designed in such a way that it encouraged you to do exactly what Bao is telling you to do, which is don't just do a quick PPA sketch, which is what a lot of people think a PPA is for. They think, oh, if I just get my basic idea down there, I can file the PPA and I'm safe. But that's not true. That's not the way it works. You can't represent in a converted utility patent what you didn't represent in your PPA. And so it was really important to the community to make sure that a tool like this was developed so that when the average inventor was using it, what they were producing was a good PPA that could then go on and help them enjoy longer term protection.
Great. Well, thanks. We'll show you some the tool, and some of the few people who've used it, they've generated amazing results. I had one beta user who tried this, and he has never seen a patent before, and he wrote something that just blew me away. But we'll get to that later. But first, let me take this opportunity to introduce Dr. Phi Nguyen. He's a surgeon and a co-founder and founder of MIBA Medical Inc. And let me pass the phone to him, and he can speak a little bit about how his startup, Silicon Valley startup company, deals with the effects of the new law. Phi?
Hi, everyone. Hope you can hear me. I'm Phi Nguyen, and I had the pleasure of using the Power Patent software to help jumpstart my startup company here. We're just a small medical device company in the dermal filler space, and while I was inventing this, it came upon me that I really needed to make sure that my ideas and inventions are protected with patents. I tried to find what's the easiest and most cost-effective way for me to go about it, and this seems to be the right solution for my company. It was easy for me to just type in the subject matter that I was interested in, and to see a list of similar patents and things out there without me having to do or knowing how to do a full search of the space. And I was quickly able to see what was out there to show that my invention was actually unique and that I should go ahead and protect it with patents. And it also allowed me to see some of the sample patent in the similar space to kind of aid me in how to write my patent itself. Since I've never written any of this before, all this was new to me, so this was quite helpful to see a previous patent and the style it was written in for me to write mine. It also helped a lot to see that I wasn't encroaching on anyone else's space, and that mine was actually unique, and it helped me to quickly write one and file for a provisional patent. So that was my, it was very cost effective for me as a startup company to use this also, because we did a lot of work that usually you would have to hire a patent attorney to do, and now by the time you are ready to speak to a patent attorney, you have pretty much a lot of the legwork already done, already saving you quite a bit of money on that end, and time also. So I know Bao and the folks there have some sample coming up to show you how the workflow goes and how easy it is to use the Power patent, but just wanted to speak to you briefly regarding my experience and how I use this to jumpstart my business.
Well, great. Well, thank you, Phi. So we have some slides that you know that shows this, but I think the most fun is actually to see it live in operation. So I am going to bring up a live demo. So in this example, I've typed in the text in advance to prevent you to minimize you know, you from waiting for me to type in. But in this example, let's just say hypothetically you invented a car, and let's say you name it electric car. Let's just say. So you know, so you would update that, and as you can, as you type into it, you can see that the system detects from your input and automatically start hunting down similar references. We don't call this prior art because it's too dangerous to be. It is not a full prior art search, but let's just say if you want to see something for you know, an example, see if similar patents in the space. The beauty of this is that it shows you how professional write patent applications, how they generate the drawings, and it's also a sanity check on your idea. So you can just check around in you know, and you'll see how other peoples have documented inventions in your space. So you enter in your title, your background of your invention, you type in your summary, and you type in an abstract for that. The abstract is actually, if you notice here, is auto-generated from you based on the first paragraph of your summary, because the abstract and the summary in some sense is redundant. That's the basic overview of the invention. In here, if you need help, you can click on the eye and the video will pop up, but I won't bore you with that for now. Let's do something interesting. Here, what we have is you have you can import the diagrams of your invention, and you can add numbers to that, and then you can also generate descriptions on this side. Since the numbers have been pre-done on this, let me just add a new one to a blank figure just to illustrate how easy it is to generate nice graphics. So here we would add a reference number, so it auto-increment. You notice this is figure 6, so therefore it auto-numbers it to 600 range. You can then adjust your pointer, and you can make very professional curved line that looks, like the professional patent draftsman can do. And then you can type in your description here, however you like. And so you repeat this process until you got all your drawings done. And then after that, you would go into the inventor, and we will, capture your name, let's say, your first name, last name, your address. And this information will be used. You can add additional applicants if you want, but eventually this information is used in generating a cover sheet that's filed with a provisional application. So we have all that information automatically done for you, so you can't go wrong because it's in one spot for you. After you've entered in your address, your information, your contact, your docket number, you can e-sign it by doing something like this and type in your name, your date. Then when you're done with all that, you generate the patent application. So the first thing it does is when you generate it, it goes in through an automatic detection of potential duplicates for you. So here you call your real wheel 102 and 110, so that may or may not be a problem. Here you call an engine 150 and you call a gas engine 150, so that may or may not be a problem, but it's flagging slight inconsistencies in your text. You can then preview your application, and it's generating it, and it's doing it live. And so the first page of the application is your provisional. Then it goes into your background, your summary, and so on and so forth. So it generates that complete set ready to go. Then you can run a diagnostic on this too. And let's see, I wonder where the diagnostic went. It may have hidden somewhere, but I'll show it to you. We have it in a different slide, so we'll show you that later. So at that point, you can either self-file or you can request an attorney review. And so we at Tran & Associate we'd be happy to review it for you. But in case you self-file, you have a choice. You can do online filing, or you can file it by printing it out and regular mailing it. So when you file online and you click on that, it's going to bring you into the patent office. And all you do is you enter in your first name, last name, email address, and you say this is a new application, and you type in and you select that it's a provisional. And you just follow that process, and you can, do your own e-filing, and it's very convenient. And so that's kind of in a short demo of the application. I'll show you the report that it generates right now. So this is the report. Oops, let me go back one. So this is the report that it generates, and I need to bring up the PDF of that. But that's just I guess it's a screenshot of the first page of that. But it goes through your different sections, and it can tell you, if your title exceeds a certain size limit that the patent office doesn't want. It helps you with discussing your background and various factors in writing the background, and it will point out any potential formality errors that you may have. So. All in all, we think that this tool provides a very high, it allows you to draft a very high quality application